Well, hello everyone and welcome. My name is Megan and I'm one of the events associates here at the Animal Legal Defense Fund. Today we will be celebrating a victory for plant-based foods, free speech, and consumers. This webinar does offer closed captioning. If you can turn it on by clicking that CC button at the bottom of your screen. We'll have a brief Q&A at the end of the presentation and you can submit your questions anytime using the Q&A button also at the bottom of your screen. Joining us today are Amanda, Morgan, and Michael, all members of our litigation team. Our litigation program files strategic impact lawsuits in federal and state courts across the country to improve the lives and advance the status of non-human animals. And now to get things started, I will pass things over to Amanda.
Thank you so much, Megan. It's very exciting to be here and especially to give an update on a recent victory, as you said, in our case, Plant versus PBFA v. Shuford. I guess I should say all of what we discussed today is our personal views and opinions. Not taking it personally that I always have to say that because I think that maybe I talk out of turn and get a little spicy, but here it's a win, so I probably won't do that too much. So today we're talking about giving an update on our tag gag laws. For those who don't know, tag gag is what we call when states have passed bills or laws that basically constrain the ability of plant-based foods and plant-based food producers to truthfully convey the nature and contents of their products on their labels and in their advertising. So again, talking about plant-based here today. I think folks have probably known that in the past 10 or so years, we've seen kind of a huge rise of plant-based in terms of interest and consumer consumption. I will say that plant-based foods have been around for, I mean, since time immemorial, for thousands of years, because it's just foods. If we're talking about plant-based foods that replace meat products in terms of their organoleptic properties, how they taste, what they look like, how they act, what they are used in to replace a meal, those have been around for centuries. And in this country, those organoleptic substitution type products have been around at least since the 1900s, the early 1900s. Again, in the last 10, 15 years, we've seen a lot of growth in terms of popularity, demand, investment, marketing devoted to plant-based foods. Plant-based foods, as we see on this first slide, are regulated by the Food and Drug Association. FDA regulates most foods in this country, with the exception of meat and poultry products, which falls under USDA. As we can see here, there's an onion of laws that apply to plant-based foods slash what we just call them foods. FDA has the Food, Drug, and Cosmetic Act. That has a catch-all provision that prevents any foods from being false or misleading in any particular. It also has a bunch of regulations that control what appears on the front of a package, what we call the principal display panel. Um, and it has even an express preemption provision, which Michael and Morgan will get into a little bit later, which basically means that what appears on that front panel is uniform for products and food producers throughout the country. That's so that consumers have, the same expectations and have access to the same information. But maybe even more importantly, it means that food producers know what has to appear on their products in order for the products to be shipped nationwide and not just state by state, because that would be pretty untenable, having to have 50 different state by state labels. So that's the federal kind of side of things. I'd be remiss if I didn't say that there are also state laws controlling the truthful and non-misleading nature of plant-based food products at the state level. Like all 50 states have unfair, deceptive acts and practices laws, consumer protection laws that also prohibit products, not just foods, but all products from being from tricking consumers. And they do also have state-based, like Food and Drug Cosmetic Act kind of laws, or adopt the federal Food, Drug, and Cosmetic Act. So that's a whole long-winded way of saying um, plant-based products have long and always, since these laws have been on the books, and probably even before that, had names that truthfully convey their nature and contents, that have uniform labels nationwide, and have long had to comply with these things. And so, again, this just means that they're applied to all federally regulated foods. Plant-based foods are complying with these laws for decades. Again, when you think about it, They're always sharing that they're vegan. It's a feature, not a glitch. And they don't want to be confused with plant or meat from slaughtered animals because that's their marketing, their selling point. Um, I'll also note, because this is relevant to a portion that Morgan's going to cover later, um, most plant-based producers, like most food producers, packaged food producers, rely heavily on third-party distributors to get their products to consumers. They also rely on nationwide retailers. And I mention that because retailers and nationwide retailers and third-party distributors sell by the region or by, the nation. They need undifferentiated products. They can't be told to only sell this one product in this state and avoid this other state. They have warehouses. They have this whole distribution system. And if they were told that they had to avoid a certain state, that because this label can't appear in that state, there's a good chance that they would just simply drop carrying that product. And then plant-based food producers themselves, it's obviously too burdensome for them to self-distribute. That's kind of a huge ask. So again, they can't self-distribute. Store by store differentiation is too burdensome. And I think that the meat producers kind of they're aware of that because in some ways they're similar, not necessarily in the distribution, but in some ways. So I mentioned earlier that meat producers, or that plant-based meat producers started getting more part of the market share of late. I think, for instance, and that goes for all plant-based products. Like I think for plant-based milks, they have 15% of the market share. So that's really concerning to their animal-based competitors. So because of that competition, we saw a spate of industry lobby groups representing the dairy industry and the meat industry taking a run at federal agencies that regulate plant-based, asking them to prevent plant-based from using either milk and dairy terminologies or meat terminologies in the description of their product. Again, plant-based meat products have always been saying like vegan sausage or a veggie burger. They don't want to be confused, but it was the position of their competitors that they should not be able to use those meat terms at all, even if it meant that it was the only and best way to convey to consumers what to expect from a plant-based product in terms of its function and flavor. Um, so here's just a list of like the different attempts the meat and dairy industry made um, to take a run at the federal government to kind of constrain their competition, attack the plant-based competition. These things didn't really uh, have any success. One of the reasons for at least the U.S. Cattlemen's petition in 2018 to USDA was because they were petitioning the USDA, who does not regulate plant-based products. That would have been FDA. So they didn't have a lot of success. And what we saw after that then was them attempting to take a run at the state level, which meant that we saw industry groups, including state affiliates of the Cattlemen's Association, being very involved in the development of these laws that we're here to talk about today. The first one is in Missouri, and that was in 2018, and then it kind of snowballed from there. Um, I'm not going to get too far into the weeds of these laws. I think the takeaway that's important here is that there are two types of laws. First, there's bans on speech, like in Missouri, Arkansas, Louisiana, where they're saying that you can't say meat as part of your label. You can't represent yourself as meat. It doesn't matter if you have qualifying language. You may not use these terms. And in some cases, it was unclear what else would run afoul of the law. Like, would a picture of your plant-based product, meat product, run afoul of the law? In Louisiana and Arkansas, they said like you can't use a term that's been historically defined, and it's like that's very confusing. And if you're a plant-based meat producer, you don't know even how to comply with those laws. After those types of laws, we also saw in Oklahoma and Texas. Texas is what we're here to talk about today. A second type, which is adding onerous and unnecessary state-specific front label disclosure requirements for plant-based producers that went above and beyond what was already required by FDA. Just, truthfully label the nature and contents of your product and have a truthful name. So these kind of had the goal of creating a patchwork of laws throughout the country so that plant-based producers could not sell their products nationwide, which might mean that they could not sell their products at all. Um, but for purposes of time, I'm just going to say that we've had a lot of different cases here. This is a list of basically all the constitutional challenges we have brought against these laws. And also, I should say the Miyoko's case was an enforcement action by the California Department of Food and Agriculture. Um, we have been like happily very successful at and these constitutional challenges. Um, in Louisiana, we got an excellent ruling on motion for summary judgment, and then a Fifth Circuit ruling vacating that ruling, but basically reading the law out of existence and saying that, only when a plant-based meat producer is intentionally trying to trick customers, would it be enforceable under the law. So that law basically, I think, is going to be not applicable to any plant-based producer. We got something also, and here's some just quotes. We got an excellent ruling on Arkansas, basically saying that the law was unconstitutional in a number of different ways, facially and also as applied to tofurkey. Miyoko, same thing. We got an excellent as applied ruling saying that the state could not take enforcement action, and Miyoko could use the term vegan butter, and butter is, that name is constitutionally protected, and the dairy industry doesn't own the term butter. Missouri, because of how weirdly the law was written, and the same goes for Oklahoma, the court said that it either doesn't apply at all to plant-based producers because of where it was, or in the case of Oklahoma, it only applies to plant-based producers who are also selling meat products. So I think we're going to count those as wins. I think even more exciting is the Texas law. So with that, I'll hand it over to is it Michael or Morgan, or who's going first?
That's me, sorry. I was trying to find the unmute button. Um, Thanks, Amanda. And hi, everyone. My name is Morgan Boutilier, and I'm a staff attorney at the Animal Legal Defense Fund. And now that Amanda has uh, given you kind of the broader landscape here, why these laws exist and how they harm the plant-based industry, and what happened in these other cases, I want to zoom in on Texas's law and our challenge in Texas specifically. So, ooh, okay, now I'm writing on the PowerPoint. Okay. Oh, here we go. So in 2023, after seeing what happened in these other constitutional challenges to these types of laws, Texas passed Senate Bill 664, which amended its health and safety code to add a new misbranding provision that targeted plant-based labels. So here you can see the full statutory text, but it basically says if you are selling a plant-based product, um, it is misbranded, meaning illegal to sell, unless it includes one of these qualifying terms like analog, meatless, plant-based, made from plants, and that qualifier appears in prominent type equal to or greater in size than the surrounding type and in close proximity to the name of the product. And it's important to note here that there are criminal penalties for noncompliance, and there's no intent requirement. So even if a producer does not intend to pass off their product as slaughter-based meat, um, if they're found to not comply with the letter of the law in the opinion of whoever is enforcing it, then they can be held criminally liable. So with that in mind, I want to show you what our clients' labels look like. So here are three of Tofurky's products that they're selling. I think that looking at these labels, we can all agree that no one is going to be confused that they are buying a plant-based product. Tofurkey is not trying to hide the fact that their products are plant-based. They are trying to emphasize it with these labels because, as Amanda said, that is a selling point. Here you can see that that can be done in a number of ways. Um, so, so first, Tofurkey has the brand name Tofurkey in large letters on the front of the package, and that is a well-known plant-based brand that has been a staple of many a Thanksgiving with vegetarian guests present. They also prominently use that word plant-based in big letters on the front of the package. There's a vegan stamp on each of these packages. And then on the burger package, you can see that there's a side panel that says things like friendliest food on the plate and good food is kind to people, animals, and the environment, which is them actively highlighting the benefits of choosing a plant-based alternative. And as Amanda explained, this is completely standard across the industry because plant-based producers want to um, tell consumers what their products are. But the problem is that even with labels this transparent, it is uh, really hard, if not impossible, to tell whether they comply with Texas's law. And if we look at the law closely, it seems like they might not. Um, Plant-based here appears in slightly smaller text than the subsequent words. It's unclear what Texas considers the name of the product, so that makes it unclear whether plant-based is in close enough proximity to the name of the product. Um, and nowhere else in the law or the health and safety code are any of these questions answered. Um, and this is pretty big because the consequences of getting it wrong are criminal. So this means that Tofurkey is left with these three options, and every single one of them is bad. So their first option is to continue selling in Texas and just keep their labels as is. But the risk here is that they could be held criminally liable. And At the time of this case, enforcement officers were actively out in the field looking for violations. So this was very much a live threat. So a second option is to create Texas-specific labels, but the two problems here are first that the law is so vague that it is impossible to tell how to comply with it. Um, and the second problem here is that even if they could figure out how to redesign their label in a way that complies with Texas's law, um, like Amanda said, that uh, is impossible for a brand like Tofurkey to do because Tofurkey isn't big enough to have their own distributors. So they are relying on these regional third-party distributors and um, these nationwide uh, retailers like grocery stores and things like that. And if they uh, try to keep certain products from going um, into Texas, then they will probably just get dropped and they won't be able to sell their products in grocery stores and maybe just not even at all. So then you might think, well, okay, then why can't they just redesign all of their labels so that all of their labels comply with Texas's law? Um, and The problem here is that they would be looking at 75 to $100,000 per product in design costs alone. They also have a bunch of packaging inventory. Um, in storage, so they would have to write off up to 2 years of this packaging inventory. And then they would have to mark down all of their current products in order to get them off the shelves, and they would probably have to take a loss for that. And then I think the most important point here, and the reason that these cases matter so much, is that if every single state gets to enact its own specific labeling requirements that plant-based producers have to abide by, um, then if Tofurky redesigns its labels to comply with Texas's law, then it might put it out of compliance somewhere else, or maybe another state will enact an even stricter law, and they will have to go through this expense and process again. Um, so this is why we have labels regulated at the federal level, and so this means that Tofurky is left with no good option, um, and that is by design. So the stated justification for the law is consumer confusion. And the argument here is that 1 in 5 Texas consumers are deceived because they can't tell plant-based products from slaughter-based meat, and the state needs to step in to protect them. And that number came from this survey that was commissioned by the Texas Cattle Feeders Association and the Texas Farm Bureau. And it got picked up and was heavily publicized by the industry. Um, but when we went to actually look at it and see what the survey design was, what data they had, we couldn't find it. No results were ever published anywhere. We tried to get the data through multiple public records requests, including to Representative Buckley's office, who is here quoting the survey, and who is the sponsor of the bill. Um, and nobody had it, so we have no idea how they got to this 1 in 5 number. Meanwhile, when our experts ran their own survey, they found that 96% of Texas consumers were uh, able to correctly identify plant-based products for what they were. And then I also want to note that the survey found that the law might actually increase consumer confusion because nobody knows what analog beef means. Um, and then on top of that, Texas regulators had never received a single consumer complaint about plant-based labeling. And the state agency's own representative admitted that they have never reviewed any study on consumer confusion before this law went into effect. So this consumer confusion story just doesn't really hold up. And the thing is, even if consumers were somehow confused, or a plant-based producer came out that wanted to try to pass off their product as slaughter-based meat, there are already so many laws in place to address that. Amanda talked about the Federal Food, Drug, and Cosmetic Act, which says that a food is misbranded if its labeling is false or misleading in any particular. The FTC Act prohibits unfair or deceptive acts in commerce. Texas also has its own Deceptive Trade Practices Act. And the Texas DSHS already has the authority under the Health and Safety Code to regulate the misbranding of food products, which includes plant-based products. But there have been zero enforcement actions under any of these laws against plant-based labels in Texas, again, because these labels aren't misleading. So if this law is not about consumer protection, then how did it get passed? Well, we know that Texas is the #1 cattle producer in the United States. We know that at least two of the bill's sponsors were cattle ranchers themselves. We know from reviewing records that the Texas Cattle Feeders Association and the Texas Farm Bureau played a very large role in drafting the bill. Um, Again, those are the same organizations that came out with the 1 in 5 Texans are confused survey. And then also when we were looking at the state's internal documents and communications, we saw lawmakers and regulators speaking very negatively about the plant-based industry, um, even referring to it as the anti-meat market. So, as Amanda said, the law is actually just about putting plant-based producers in this impossible situation, um, because these products were taking over a growing share of the market. Then, rather than compete fairly, these slaughter-based meat producers wanted to get these products off the shelves. Um, but protecting market share for an in-state industry is not a constitutional basis for this type of law, which brings us to this lawsuit. So our plaintiffs are Turtle Island Foods, also known as the Tofurkey Company, the Plant-Based Foods Association, which represents over 300 plant-based producers. Our litigation team was joined by the Good Food Institute, Kittner Woodward, and Jones Walker. And then the defendants are the Texas officials responsible for enforcing the law. So the commissioners of the relevant state health agencies, and Ken Paxton on behalf of himself and all Texas prosecuting attorneys. So with that, I'll hand it over to Michael.
All right, taking control back. Thank you so much, Morgan and Amanda, for setting that all up. For the next few minutes, I'm going to talk about the legal arguments that we made, what the court thought of them, and where things stand as of today. In our case, we made 4 key main arguments, and I'll run through them all one at a time, but just to preview them all. The first argument is that the law, Senate Bill 664, violates the First Amendment to the Constitution, that the law is unconstitutionally vague in violation of the U.S. Constitution's Due Process Clause, that the law is preempted by the Federal Food, Drug, and Cosmetic Act, which Amanda spoke about already, and that the law violates what's called the Dormant Commerce Clause. The First Amendment, which you're probably all familiar with, protects freedom of speech. That includes corporate speech or commercial speech if it is not misleading and not related to an unlawful activity, which we argue was the case here. These labels are not misleading. Certainly nothing that Tofurkey's doing is unlawful. So then a restriction on speech becomes evaluated or analyzed under what's called the Central Hudson Test, and that gets its name from a Supreme Court case with that title. Under the Central Hudson Test, a law that restricts speech that would otherwise be constitutionally protected, that restriction can still stand if there's a substantial government interest, if the restriction on speech directly and materially advances that substantial government interest, and if the restriction is not more extensive than necessary, if it's kind of narrowly tailored to the concerns that we're talking about here. And we argued, as Morgan talked about, there's no evidence at all that consumers are confused about these labels. There's no evidence that the changes the law would make would alleviate any of that concern, even if that concern existed. In fact, it might make things more confusing. And finally, again, as Morgan talked about already, misleading or misbranded labels are already illegal, both under federal and Texas law. And so creating a restriction that applies to all plant-based labels is way more extensive than necessary. Under the Due Process Clause of the U.S. Constitution, there's the principle that people need to understand what the law means to know how to follow it. We argue that this law, Senate Bill 664, violates that because it fails to properly articulate what is and is not prohibited, what conduct is specifically being required. Again, as Morgan said, phrases like name of the product and surrounding type are not defined anywhere in the law, and those are the yardsticks against which you have to measure compliant conduct. So if companies don't know how to comply, that allows for arbitrary and discriminatory enforcement by state enforcers. We already saw examples of Tofurkey labels, and we're not entirely sure whether they conflict with the law or how they might need to change. But the example that the state gave in response was 2 different cereal packages. And we thought they didn't really help alleviate concerns either, because if you look at Lucky Charms S'mores or Trix Minis, it's not clear if the name of the product is Trix Minis, Trix Minis. Is it artificially fruit-flavored sweetened corn puffs? Some combination of all those things, which appear in different fonts, different sizes, different colors. Who knows? The third argument we made is that the Texas law is preempted by the Federal Food, Drug, and Cosmetic Act. In 1990, the FDCA was modified, by the Nutritional Labeling and Education Act. And as Morgan again spoke about, the reason for that modification was to make sure that there's a national uniform standard for food labeling in all 50 states so that the food industry, producers can market and sell their products nationwide. It's one country with one market for these products. That contains an express preemption provision that says that no state, so no state or local government, can directly or indirectly continue in effect as to any food in interstate commerce, quote, any requirement for the labeling of food that is not identical to the requirements cited by that preemption provision. And during this case, defendants acknowledged that the law imposed requirements that were different from or in addition to what's required under federal law. So it's preempted by federal law. The final argument we made is that Senate Bill 664 violates the Dormant Commerce Clause. The Commerce Clause of the U.S. Constitution says that it's Congress that has power to regulate commerce between the states. And so the negative implication that the Supreme Court has read into that is that if Congress regulates interstate commerce, therefore individual states cannot do that. Individual states can regulate what happens within, say, Texas's border, but not between other states or outside of Texas's borders. A law can violate this Dormant Commerce Clause in a number of different ways. The first couple are all versions of economic protectionism. A law can purposefully discriminate against things that come from out of the state, or they can do that by effect, even if there's no sort of express purpose to discriminate. And we argued both of those applied here, that as Morgan talked through, this law was drafted with help from in-state animal ag interests. Lawmakers and regulators that would enforce the law both spoke negatively about the plant-based sector broadly and spoke about the importance of protecting in-state interests. And those are the kinds of things courts consider when they're looking at whether a law was passed with a discriminatory purpose. Setting aside purpose for a sec, we argued that the Texas law also discriminates in effect against interstate commerce and the ability for plant-based companies to sell nationwide. Again, as both Amanda and Morgan spoke about, the nature of the plant-based industry makes it, quote, technically impossible. That's a quote from one of our experts. Given the nature of modern distribution networks, online resellers, nationwide chains, it's technically impossible to comply with this law and still be able to sell nationwide. The final way that a law can violate the Dormant Commerce Clause is through what's called the Pike balancing test. And there you balance the burden on interstate commerce with the benefit to the state itself, like any in-state local interest for Texas. As we've already talked about and we argued, this law significantly hinders the ability for plant-based companies to engage in the interstate marketplace to sell their goods nationwide. On the flip side of that balancing test, Texas didn't produce any evidence at all that there was a local interest. There was no evidence submitted at all that consumers are confused in Texas. There was no evidence submitted that even if consumers were confused, the law would in any way improve or change that for the better. And so we argued the balance here is way on the side of burden and no local interest. We made all four of those arguments in our first complaint and our first amended complaint, which we filed in the fall of 2023. Texas moved to dismiss the case, as is pretty standard in civil cases. We won on the order denying motion to dismiss later the next year in September of 2024. We then entered discovery. That's the period of the case where you're developing the facts, giving documents back and forth, conducting depositions, that sort of thing. We filed our cross motion for summary judgment last summer in August of 2025. This January, just a couple months ago, the judge ordered supplemental briefing, which I'll talk about in a minute. And then the final order was issued on January 28th, 2026, early this year, and we won, which is the highlight. I'm going to talk through the final order and where things stand as of today. In the final order, the first thing the judge talked about is whether the plaintiffs had standing to bring this challenge in the first place. And when you bring a case on behalf of a party where enforcement against them hasn't happened yet, so it's a pre-enforcement challenge, the plaintiff has to be able to show that they want to engage in something that's constitutionally protected, that conduct is arguably in violation of the statute you're challenging, and that there's some sort of credible threat of prosecution. And we argued all these things hold, and the court agreed. The court said, look, it's clear that Tofurky's labels are the kind of commercial activity the First Amendment protects. As this court had already said in an earlier opinion, Tofurky has products where the words maybe aren't quite the same size as one another. It's totally possible that their conduct is prescribed by the law, that violates the law. We don't know. And then finally, courts will assume there's a credible threat of prosecution under a law, particularly a recently passed law. But here we even went beyond that and we're able to show like people from the state enforcement agency said that there's officers out in the field looking for violations. So this law is being enforced. So we won on standing, case able to proceed. They talked about the merits of the First Amendment. And the focus on the final order was really on our First Amendment argument. The court agreed that plaintiff Tofurky's labels are not misleading, so the First Amendment applies to them. They then moved on to that central Hudson test that I described, and they said that defendants, the three Texas officials that we sued, have not demonstrated that the law's restrictions target a substantial government interest. They presented no evidence at all of consumer confusion, and there's already laws, again, as Morgan and I both spoke about, that regulate misleading conduct to the extent that exists at all. A government seeking to restrict commercial speech has to show that that restriction will alleviate the concerns. And there's both Fifth Circuit and Supreme Court precedent showing that. And the court agreed with us. There's no evidence that this advances any interest or that said interest even exists. And the law, like I argued earlier, is far broader than it needs to be. So the court agreed with basically all our First Amendment arguments, which is fantastic. The court then moved on to the question of whether the law is unconstitutional as applied to Tofurky or whether it's facially enjoined, meaning the law can't be enforced against anybody, not just our clients. The way that courts analyze this in recent years is from a new Supreme Court case from a few years ago called Moody v. Net Choice, where the court looks to whether a substantial number of the law's applications are unconstitutional and judge those in relation to the law's constitutional applications. Again, another sort of balancing test. Courts love those. So the two steps in the Moody analysis is what activities does the law regulate? And when you consider the regulating sort of activities that are unconstitutional, how do they measure up against constitutional ones? So in this case, this is what we argued in supplemental briefing. This is what the judge wanted, sort of additional analysis from the parties on. The court ended up saying that the state law, Senate Bill 664, regulates the non-misleading labeling of analog products by plant-based food manufacturers. And they reached that point by saying, like, look, we need to look at what this law is doing that's new, not just where it might overlap with laws that already exist and things that are already illegal. What is it actually changing? And it's regulating labels that are not violating other laws, aren't misleading. Then balance that with the constitutional and unconstitutional applications of that regulation. And here's what the court said. Quote, in sum, even in situations not apparent in the record where a plant-based food product label misleads consumers, existing law would prohibit those labels except in possibly a small minority of circumstances not made apparent to the court. The law is invalid in a substantial majority of all applications and is appropriately enjoined facially. So that means that the law cannot be enforced against anybody going forward because it violates the First Amendment, which is fantastic. As things stand right now, the state has appealed that decision to the Fifth Circuit, and so watch this space. This is ongoing, but we will now take any questions from the audience.
Alrighty, thank you guys. And yeah, we will open it up for some Q&A. So if anybody has some questions, please use that Q&A feature and go ahead and submit them. And we have a couple that have come in. One is, would any of you guys like to talk a little bit about how we use the dormant commerce clause, how that was argued in this case versus maybe how it was argued in like the California Prop 12 defenses?
I can start on that one, and Michael, Morgan, if you want to chime in, I'd be very welcome to. So we were actually, it's a good question because we were on opposite sides of the argument for the Dormant Commerce Clause, defending Prop 12 a state law versus attacking a state law in Texas. There are a couple, because after the National Pork Producers Association v. Ross, after that Supreme Court decision, we've learned that we're basically in pike balancing land, which is what Michael was explaining earlier, which is kind of an inherently fact-based question and analysis. So here, I think we've made pretty clear that the facts on the ground is there is no consumer confusion. The state interest that's being weighed in the pike balancing is purely pretextual. So it's like, it's pretty light. It's like this law doesn't accomplish anything. And then you weigh that with the burden on an interstate market or the flow and instrumentalities. Here, the flow of commerce would be, it's not just harm to a particular producer, it's harm to the market. And here we were able to show, thanks to experts, thanks to testimony from our plaintiffs, that they wouldn't be able to sell their products at all, not just in Texas, but like it could eviscerate the plant-based market because of their nature of their distributor relationships. Um, that wouldn't work for pork producers or meat producers. They're so vertically integrated, first of all. They don't rely on those third-party producers. They can and do already control where their products end up. And even before the NPPC v. Ross challenge, they were already avoiding, like making sure certain products got into California and other products non-compliant with Prop 12 products stayed out of California. So they had that capability. The pork producers, that industry group, were basically arguing wrongheadedly that like this is going to hurt our bottom line, and this might even increase costs to consumers. The Supreme Court was pretty clear in the case law leading up to that, has always been pretty clear. Again, harm to individual producers, even in industry, cost-wise and stuff, isn't harm for Dormant Commerce Clause purposes. It was not affecting the instrumentalities of commerce. Um, so, even though we were on different sides, kind of like arguing that law, we, I think, don't argue it any, like the law is the same regardless. It's just the facts are different. Um, so I think that, oh, and then in the NPPC Ross, the Prop 12 case, there you had evidence, and it was at the pleading stage that got up to the Supreme Court, but we do have evidence, and there is evidence existing, that the two substantial state interests cited to justify that law, compare contrast with the Texas law, there is no actual justification for the law because there's no consumer confusion. And in Prop 12 does two things. It protects animal welfare, which we know it does. Not having intensive confinement and not having such intensive confinement is better for animals' welfare, their psychology, their ability to engage, and just being literally able to like turn around and lay down and stuff. So that of course increases animal welfare. It also increases the likelihood that the food products made from Prop 12 compliant producers is going to be safer and less likely to have food safety risks. So that's a pretty high thing to balance when you're talking about animal welfare and also food safety for consumers, and that those are very real concerns. Just as an aside, I have to say the Prop 12 case is very exciting because one of the reasons, because we have the Supreme Court acknowledging that animal welfare, it can and was a substantial government interest, that we're allowed to care about that. So I hope I answered that question.
Excellent. Thank you, Amanda.
Mhm.
One other question that has come in, and first off, there's been lots of compliments to all three of you guys. But one other question that has come in is referring to the health department and the food pyramid, referencing that right now PCRM, or Physicians Committee for Responsible Medicine, is suing the health department over the food pyramid. Do we have any work on that or any discussion there?
I have to say PCRM is a great organization. That's something that has concerned us before. Again, Michael, Morgan, please jump in. I'll just get us started. I will say that the background of this is interesting because it almost feels like, the nutritional guidelines, the food pyramid, the My Plate that preceded it has always a little been kind of guided by agency capture. The USDA and FDA are so beholden to corporate interests. I think that if those guidance documents were actually reflecting the significant scientific agreement on what is healthful and safe for Americans, I wouldn't see. Here's where we have the admonition: personal views. I don't think that they would have red meat and highly processed meats on those in those suggestions, dietary guidelines at all. They're certainly not necessary for survival, and they increase, a lot of health concerns and risk of health concerns for people. So while we don't have a lawsuit against that currently, that is something that we have worked on and submitted regulatory comments on and supported other organizations in doing. What am I missing, Michael? Morgan?
I don't think you missed anything, but I'll add in and say, I think I'm also, speaking my personal capacity, happy that PCRM is doing this. They're, as an organization, very tuned into the health kind of medical side of things, more so than at least I am. I'm not a scientist. And I think the through line of what Amanda was just talking about in the case that we presented on today is that regulatory and agency capture argument that both at the federal and state level, there's a lot of government machinations happening to try and make things harder for plant-based products, whether that's onus labeling requirements or making it easier for animal-based, slaughter-based products by recommending people eat them or slashing red tape for them.
Oh, I just got reminded of one more thing. Sorry. Thanks. I hope we have time. So again, like this overarching thing, this has always existed regardless of which administration is in power at that moment. The new kind of tack is something that we're seeing against plant-based, since the theme here is, industry attacks, slaughter-based industry attacks on plant-based meat products and dairy products. The new one that we've seen in this administration and with this head of HHS is more along the lines of like ultra processed, which, a lot of people are hard pressed to even define. And they try to denigrate the health aspects of plant-based meats. I think that is one of my biggest personal concerns, plant-based meat products. And I would say again, personal views here are completely like 100% and always healthier than slaughter-based meats. They don't have cholesterol, they don't increase the risk of like colorectal cancer, prostate cancer, all these cancers. With GLP-1s and gut motility, that like it feels like it's even riskier to have those products, the slaughter-based animal products sitting in your guts for longer. And they were pointing to things like sodium content and stuff. Which they have to add because the naturally occurring sodium is like, I guess, like, I don't even know. I would say it's like almost non-existent in like a pea or something like that. So it had to be added. And I would say that in terms of the chronic diseases that Americans struggle with, which I think is still number one cardiovascular disease, that's going to be more affected by cholesterol, which is not contained in plant-based products. So I think if people are trying to eat healthier, they should be eating more plant-based products. And again, this whole like ultra processed tack is concerning because in a lot of cases, these like tofurkey you can make in your like, not to out them, but you can make that in your own kitchen. It's basically tofu and seitan, which are kind of whole ingredients. So I think it's pretty wrong-headed and specific to the administration in terms of the new attacks on plant-based. Sorry if that ran a little far afield.
No, that was fantastic. And thank you guys all. We are running out of time today, and that was our last question. So we'll go ahead and wrap things up. If anyone does end up coming up with any other questions, all of our speakers' email addresses are up on the screen. So feel free to jot them down, and you can always reach out to them if you have any questions. You can also always reach out to us at events at aldf.org if you have any questions, and we're always happy to help you. Most importantly, thank you, Amanda, Morgan, and Michael, for joining us, for sharing your expertise today. And thank you to everyone out there for taking time out of your busy schedule to join us. We truly appreciate each and every one of you. We couldn't do this work alone. So thank you all for being a part of the Animal Legal Defense Fund community. Enjoy the rest of your day, everyone. Thank you.